Okay, are we ready? Okay, everybody, thank you for joining this webinar on adjudication, jurisdiction, natural justice and enforcement in the time of COVID-19. This is going to be a whistle-stop tour through some of the recent decisions in relation to adjudication. My name is John Denis-Smith. I'm a barrister at 39 Essex Chambers, specialising in construction and commercial, including adjudication and arbitration. And David Sawtell is also a barrister at 39 Essex Chambers, and he specialises in property and construction work and in adjudication in particular.
So what we'll be going through this morning in particular, we're looking first of all at how the TCC is approaching COVID-19 and adjudication. And John is going to be looking at some of the procedural issues arising out of the adjudication process itself that we are having to deal with in the current situation. I'll then go on to consider the latest case on alleging fraud as a defence to enforcement of an adjudication decision, and then considering the issue of hybrid contracts, a thorny issue that the TCC and the Court of Appeal has had to address on a number of occasions now. John's then going to go on to consider adjudication and bonds and guarantees and how the two interface. John and myself are both going to consider crystallizing the dispute, natural justice and severance. There have been a number of decisions, particularly in the Scottish courts, about these issues, which would be equally applicable to adjudicators and to practitioners alike. We'll then finally conclude by my consideration of the latest case on adjudication by insolvent parties. I'll now hand you over to John to discuss adjudication in the time of COVID-19.
Okay, thank you, David. Now, this is an interesting decision. At the moment, we as a community have a summary available of this decision in MillChris Developments and Waters. I'm still awaiting a transcript of the full judgment. And so we're working from the basis of that summary. There may be interesting points which haven't yet appeared on Lawtell, etc., to come. But there's enough in terms of that summary to go on the way, in terms of the way that the courts look at these matters. Now, this is the first COVID-19 adjudication case, and it's a COVID-19 adjudication point as opposed to an underlying dispute in relation to COVID-19. No doubt those sorts of disputes are going to come roaring away in due course. The background to this particular dispute is that the applicant was seeking an injunction to prevent an adjudicator from continuing to act. As you'll know from starting Wednesday, the injunction of that nature in clear-cut cases. In this case, what had happened was the applicant had carried out works at the respondent's property that started in autumn 2017, ceased trading in late 2019, and in March 2020, respondents to the application for the injunction commenced adjudication proceedings. An adjudicator was appointed who timetabled the submission for evidence, provided for a site visit, and a couple of weeks after that, the adjudicator stating it wasn't possible to comply with the deadlines because of the COVID health crisis and asking for postponement, the adjudicator decided that the adjudication should proceed extension, which was refused by applicants. The applicant instead made the application for an injunction. It was Justice Shepherd who refused that application. The test in these situations is whether there's a serious issue to be tried, in that the adjudication would necessarily be conducted in breach of natural justice, with the inevitable consequence that it would be unenforceable. That's the hurdle that had to be covered, crossed, and it wasn't. And the interesting point for COVID adjudication purposes are the reasons that were given for why the applicant's application failed. First, no explanation as to why papers could not be transported or scanned over to the solicitor or anyone else instructed in the matter. Second, the reason that it had not been possible for the applicant to obtain evidence was held not to be to do with COVID-19, but from an inability to contact the applicant's former managing director. Third, the applicant had not attempted to contact his former managing director, his former project manager.
Now, I think John is cutting
Do you
out
have me?
a little bit there. John, I can hear you now. Just to keep an eye on that, and I might need to step in at some point if we get any signal interruption. I think John has gone muted there, and just want to pick up where John was going from. So the natural justice injunction was refused. As we know, it's a very high threshold to get over in order to get an injunction to stop an adjudication. John, do you want to pick up where you had got to?
Yes. What was the last thing that people would have heard?
I think we're just concluding the discussion of the injunction and why the three reasons why the injunction was refused by the court.
Right. So the other factors were, so failure to seek to contact the former project manager, and beyond that, the applicant should have accepted the offer of an extension of time, and the applicant's complaint that it was not able to attend a site visit failed on the basis that parties do not have a right to attend a site visit, and although the respondent did attend, and I'm going to go to I'm going to stop my video and go to sound only. So I hope, could you hear me now?
That's good, John.
Excellent. So you're going to hear me as if a voice from afar. Mr. Justice Jeff had held that parties have no inherent right to attend site visits. The fact that the respondent attended the site visit was obvious because the site visit was at the respondent's own property. It was therefore clear that the respondent would be present, and Mr. Justice Jeff had made the point that it would have been possible for the applicant to ask for the site visit to be recorded, and it would have been possible for the applicant to ask to be able to list specific matters in relation to the alleged defects, which is what was an issue at that point, for the adjudicator's attention. Now, that's an important point to have in mind. The first point is that if you know anything about what's happening in the court, at least in the High Court, there are some suggestions that may differ in some of the county courts and district registries, but at least in the High Court in London, the courts have a pretty strong determination to continue having hearings and to make whatever steps have to be made to make that happen. They expect the same to happen in adjudication. So the steps are really going to be, if you want to object to adjudication proceedings, to have to show why it is that you can't take all the steps the court would expect you to take. The court will want to see evidence that all efforts have been made to use electronic means of communication, including scanning and curious. If one cannot obtain witness evidence, one is going to have to show not only that that particular witness can't give evidence because of COVID, but that problem could not be mitigated by calling evidence from other witnesses. Site visit hadn't happened yet. And therefore, one could not say that there had been any breach of natural justice yet in relation to that. There is a case, which is the case on the slide, Allen versus Connew, in which the Court of Appeal has held that a judge below was in breach of natural justice in discussions with experts during a site visit, which were not noted and therefore not the subject of later submission, because the counsel on either side were not aware of what questions had been asked or answers given. So one has to be careful about site visits, even in the light of this judgment. But nonetheless, one shouldn't assume that the absence of presence at a site visit is going to be a basis for a successful natural justice challenge. So those are the points to make on that case.
Now I'd like to come in and talk about the latest case on using fraud to assist the enforcement of an adjudicator's decision at the summary judgment stage. And we return to the failed power station project in Wrexham, which has been vexing the TCC and the Court of Appeal in a number of cases. And the latest case that's come out of this dispute is that of PBS Energo against Bester Generation. Bester Generation was the main contractor for this power station project, and PBS Energo was the subcontractor. And there had been a series of adjudications between the parties. The first adjudication was to determine whether or not PBS had validly terminated the subcontract. And the decision of the first adjudicator was yes, PBS had validly terminated it. A second adjudicator was therefore appointed to determine what PBS's losses actually were. So this was going to turn on plant, material, amongst other things that PBS had manufactured but hadn't had the opportunity to incorporate into the power plant. And the issue at Bester raised in this adjudication was a question of mitigation. They said that some of this plant, some of these materials, could in fact have been sold on the open market. PBS countered by saying that in fact this material had been stored and was still in fact in its factories in the Czech Republic. And the adjudicator held that plant items were being stored and could be delivered when paid by Bester, whenever that was going to be. The matter then went into the TCC and it went into the disclosure stage, and Bester alleged that it had discovered documents that showed that in fact the plant, which PBS had said during the adjudication had been stored, had in fact been sold. And Bester alleged in a witness statement in response to the enforcement proceedings brought by PBS that this was indeed fraud. And I note here, and I pause to comment, that they alleged this in a witness statement. It wasn't actually put forward in a pleaded defence. And the earlier Court of Appeal, or TCC and Court of Appeal decision in Eigen and Gosner, fraud was actually fully pleaded out in a defence. And Mr. Justice Fraser commented that was a good thing for Eigen Aluminium to have done. First instance decisions, Justice Pepperell held that the contractor had indeed raised an arguable case that the adjudicator's decision had been procured by fraud. It therefore refused to enforce the decision by granting summary judgment. Matter went to the Court of Appeal, who noted this was a good opportunity to explore again the question of alleging fraud as a potential defence in the enforcement of adjudication decisions. The appeal itself, PBS's appeal, was in fact refused. Lord Justice Colston made the following headline point towards the start of his judgment in the Court of Appeal. If this was an allegation of fraud that had been made in the adjudication, or instead it could and should have been made in the adjudication, then it cannot be a reason not to enforce the decision itself. One of the findings in PBS and Bester was that it wasn't possible for Bester to raise the issue of fraud during the adjudication itself. The material, they said, had only come to light during disclosure, whereas in the earlier case of Eigen, Mr. Justice Fraser said it would have been possible to raise fraud during the adjudication itself. So it's useful to note that at summary judgment stage, then if you could have used the allegation of fraud, or you did make the allegation of fraud and the adjudicator rejected it, then generally that isn't a reason not to enforce the decision. If, however, the adjudicator's decision was procured by fraud, or the evidence the adjudicator relied on was material and arguably fraudulent, and again, the test is a summary judgment test, then such allegations can be a proper ground for resisting enforcement. The key issue and the principal battleground upon which this appeal was fought was the procedural one. And as is normal, no defence had been filed in response to the claim for enforcement of a decision and the summary judgment application. Because the summary judgment application we made at the same time as the claim was issued, CPR Rule 24, subparagraph 2 says it's not necessary to file and serve a defence. And the Court of Appeal said that even in the context of alleging fraud, as a defence to summary judgment, it is not necessary to plead and serve a defence. One of the points arose was whether an allegation of fraud can indeed be made, and it was confirmed by the Court of Appeal that, of course, professional obligations on both solicitors and barristers arise. You cannot allege fraud in a witness statement or a skeleton argument without, first of all, clear instructions from your client, and secondly, reasonably credible material establishing an arguable case of fraud. So those are some key points arising as to how to allege fraud when it comes to the summary judgment enforcement stage. Now I'd like to come on to the repeated and vexed issue of hybrid contracts and payment regimes. As we all know, when the Housing Grants Construction and Regeneration Act 1996, or Part 2, was enacted, there had been considerable lobbying of the government, particularly by the process engineering and manufacturing industry, to say that it should not be a procedure for payment regime and adjudication should not be applied to their particular sector, which is why we see particular carve-outs in sections 104 and 105, in particular in respect of power generation. Section 104, subparagraph 5, however, creates a possibility that a contract is not simply a binary question of whether it's in relation to construction operations or to excluded operations, but in fact could apply to both as a hybrid. But it makes clear that Part 2 applies to an agreement only so far as it relates to construction operations. And that interpretation was confirmed by Mr. Justice Ramsey in Cleveland Bridge against Westfield Stephen joint venture. So the statute contemplates that possibility. It might very well mean that a contract is subject to two different payment regimes. So you could have a payment regime for construction operations and one for excluded operations. Now, many contracts actually try and do elide the two together. So you have one single payment regime, and there's no need to strip out the construction operations from the excluded operations. It's also noteworthy that statutory right to adjudication only relates to disputes in respect of construction operations. But as we all know, quite often parties will opt into contractual adjudication. And the question for the TCC and for the Court of Appeal has been whether it's open to parties to contract into the whole regime of Part 2 of the Housing Grants Construction and Regeneration Act. And that was what concerned the parties in Spencer against MW High-Tech Projects UK Ltd. Now, this was a contract which contained both construction operations and non-construction or excluded operations which were falling outside the Act. And the question is, if you have a payment notice, is it necessary for the payment notice to strip out the two elements to it for it to be valid? The contract itself was for a power plant, and CSL being engaged by MW to design and construct the works. When they made interim payment application number 32, they broke down the two different elements. Those parts of the application dealing with construction operations, the other parts dealing with excluded operations. Payment notice was served in response, but that did not separate out the two elements. And CSL argued that it was invalid. CSL therefore commenced Part 8 proceedings. The Contract is noteworthy because it contains the same payment regime, which incorporates, as a matter of contract, payment notices and pay less notices for both sides, for both construction and non-construction operations. However, the adjudication provisions only applied insofar as they were required to by the 1996 Act. So there was a differentiation in the contract when it came to dispute resolution for the two sides, but not when it came to the payment mechanism. CSL's argument was that the payment notice had to identify which parts were construction operations. But this was rejected most by Mr. Justice O'Farrell. It was held that parties are free to agree that non-construction operations should be subject to the same requirements as those contained in the Act. Effectively, the parties can opt in to the 1996 Act's regime of payment notices. And under such a contract, a payment notice does not need to separately state the sums due. You might very well see here the distinction between this case and the slightly earlier case of Bennett, which was decided by the Court of Appeal only a little while ago. When the matter went to the Court of Appeal, Lord Justice Colson agreed with the reasoning of the first instance judge. He held it was possible for parties to contract into the Act. Section 104, subparagraph 5, does recognise that there will indeed be hybrid contracts. He also noted the parties here had limited adjudication, but not to payment provisions themselves. So in terms of ease of contract drafting and straightforward contract drafting, I think it's going to be a sigh of relief for those of us involved in power station projects, in that it isn't, if the contract is drafted appropriately, we can all choose to opt into part 2. The question mark, however, is how this relates to Sir Rupert Jackson's comments in Grove in the Court of Appeal as to the status of section 111. So Lord Justice Colson picked up on that point, because of course Sir Rupert Jackson noted section 111 effectively trumps contracts. But I think that's going to be a point for another day. And Lord Justice Colson noted that strictly Sir Rupert Jackson's comments were obiter dicta. But surely there's going to be some more debate and argument about payment notice disputes and hybrid contracts. I'm sure the pen has not stopped writing on this particular aspect of jurisprudence. And now I'd like to hand back over to John.
Okay, let's see if it works a bit better. David, do you hear me at the moment?
Yes, I can.
Great. Okay, Uanda. Now, this is about adjudication and calls under bonds. The background to the case is that there's a dispute between Uanda and Multiplex. Each of them have claims. Multiplex commences an adjudication at the end of 2019, and the parties have agreed at this stage that the adjudicator will have until the 6th of March 2020 for the decision. Then in January 2020, Multiplex makes a call under the guarantee. Now it's the JCT design and build subcontract 2011 edition that governs relations between Uanda and Multiplex. The bond requires for a call to be made. There were 3 questions in this case. The first was, what kind of bond is that? Is it an on-demand guarantee or is it a performance bond? It was held to be a performance bond, and therefore one had to establish what for the purposes of and ascertaining loss for breach of contract. Therefore, there were 2 questions that at that stage. There's an expiry point, and there is the ascertainment and establishment of damages point. The establishment and ascertainment point was that this was not a contract in which there was provision for third-party certifier. Therefore, one could not simply say someone has certified. I'm going to make sure that I'm going to see if we can get my sound by stopping my video, and if I can't be heard, David will let me know. The claim that was being made by a multiplex was that it would be enough to make a claim for the purposes of the bond. That was decided to be incorrect. What Mr. Justice Fraser decided was that one would have to have a positive decision in one's favour in order to say that one had established an ascertained loss, and only then could one make a valid claim. And therefore, in this case, one had to await the decision by the adjudicator before making a valid claim under the bond. There's an important point here about timings. There is an expiry point, which we'll come to in a moment. And the effect of that was that one had to have a valid claim before expiry, and that, of course, was going to happen in April 2020. It was not enough to have a valid claim in the sense that one was going to prove one had an entitlement, and the actual establishment and ascertainment by adjudication, or indeed arbitration or litigation, would happen at some point after the expiry date. That was held by Mr. Justice Fraser to be an extraordinarily non-commercial interpretation of the bond. And so the expiry in the bond was absolutely like a guillotine. If one did not have a valid claim following ascertainment, one would not have a claim at all. A couple of points that arise from this. The first is what happens in other contracts where there's no provision for a third-party certifier. And an obvious one is the JCT design and build contract, because you don't have a third-party ascertaining and establishing loss in that situation either. So the question arises for that sort of contract whether they would also, as an employer, have to go down the route of obtaining a decision by an adjudicator. Another point in relation to COVID is that one has to look at the terms of the bonds, and one has to look at the terms of the contract in terms of the point at which one can ascertain loss. There's a case that you're probably aware of called Zigurat. That's a JCT 2011 case, but it's a case in which there was an insolvency scenario. And in that situation, the final account stage is the point at which a third-party certifier enters into the picture. And so for both those reasons, the expiry date point and the ascertainment and establishment by way of something other than just a claim, there could be real time pressures on parties, particularly against the background of adjudication in the time of COVID, because parties are going to be wanting to establish loss much sooner, in fact, as soon as they possibly can. In passing, this is a final point that you may want to bear in mind, because a lot of guidance notes are going out at the moment in respect of COVID from various institutions that issue standard forms. One of the issues in that case was that the bond in issue was very closely followed in terms of its wording, very closely followed the ABI model form of guarantee bonds. And therefore, one of the questions was, can one construe that bond by reference to guidance notes issued by the ABI? And it was held, no, one can't look at those guidance notes as a permissible basis upon which to interpret that particular contract. So when you get your guidance notes issued by NEC, or in due course, no doubt, other standard form bodies, you need to be aware that you may find that the courts say those are not permissible as a form of construing the contract issued by the same body. Now, the next point is, can an adjudicator get someone else to do their work? And these are the two Scottish cases that David foreshadowed. Quite extraordinarily, we're talking here about two decisions by the same judge in respect of two adjudications in which the same individual was adjudicator. I'm not sure if that's happened very often, in circumstances where the parties themselves are different. The first of these is Dickey-Moore and McLeish. So what you have here is a situation in which the parties know that there's a third party individual who's a pupil. What they don't know until later is that the pupil has carried out some tasks which the parties agree will not be considered as pupils' activities. Both adjudicator and pupil gave evidence as to what the pupil did, and those involved populating a Scott schedule, taking notes of meetings, producing the action points which the adjudicator had decided upon, and proofreading the adjudicator's decision. As part of the process, the pupil had also considered his own conclusions in respect of a jurisdictional point and sent those conclusions to the adjudicator, although the adjudicator said he didn't read them during the course of the proceedings. Once the party which lost out in the adjudication found out about the involvement of the pupil in those administrative tasks, it took an actual justice point, and the point is not, as you'll know, has an unjust result been reached, but was there an opportunity for injustice to be done? Now, the court held, in this case, and I have the quotation up here, having regarded the evidence that all the material decisions on the matters in issue were taken by the adjudicator himself. It held that the adjudicator should have told the parties what the pupil was doing, but there wasn't a material breach of the requirements of natural justice. So in that case, the objection failed. Although you have to be aware that in that case, when both adjudicator and pupil gave evidence, that all the documentation passing between them is going to be looked at in some detail. On to the next case, which is Babco and Aegis Barrier. Here you have an adjudicator appointed under clause 2.3 of the NEC adjudicator's contract, which provides, after notifying the parties of his intention, the adjudicator may obtain from others help that he considers necessary in reaching his decision. Before making his decision, the adjudicator provides the parties with a copy of any information or advice from others and invites their comments on it. In this case, the first that the parties became knew of the involvement of the QS is when, after the decision was made, they received the fee note from the adjudicator, which had the following entry: QS assistance, 28 hours, and figures for how much that totaled. So 7 months after the decision was handed down, the adjudicator, in correspondence, he didn't give evidence in the court proceedings, stated that he could not recall exactly what assistance was provided and stated what he thought the kind of assistance would have been. In that case, Lord Doherty refused summary judgment, and on the basis that the adjudicator's terms and conditions didn't state that there was an intention to employ QS assistance, this was very much a QS case. It would be going too fast to infer that this was the kind of assistance that shouldn't be disclosed. The view was given that clause 2.3 of the NEC adjudicator's contract probably meant that the adjudicator should have provided information to state, first, that a surveyor had been engaged, and second, in general terms at least, what the third party was doing, even if that assistance was administrative only. But in that case, without further inquiry, the court could not determine that the breach of natural justice was immaterial. And on that basis, summary judgment was refused. So what are the lessons from this? The first is that one really does have to state that there's a third party and what role that third party is going to play. One has to assume, if one is operating under the NEC adjudicator's contract, that the better view is that one should reveal rather than not reveal, hoping that the matter is not considered to be sufficiently material to require that information to be given. One must keep records of communications because one has to expect those to be studied. And I've given the case there of John Sisk and Giro Felguera. That's a case where the natural justice challenge failed. But in the course of the process, the court was actually looking at metadata. There was a point about who was the author of a document, and somewhat embarrassingly, it was the third party whose name was down as author. It did not prevent enforcement, but one doesn't want to get into a situation where that kind of point can be taken. So those are the points to take from the third party involvement issues. Over to you, David.
Crystallizing. Please, John.
Yes, I'll take that. LJH paving. Now, crystallizing the dispute is going to be particularly important in adjudication in the time of COVID, because parties are going to want, if they are on the end of being the payer, to delay payment, even of payments that they consider to be due, because cash flow could be a real problem. So crystallization has even more importance now than it would have done in the past. This is a decision in relation to a scenario in which 2 points were taken, amongst others, which I think are particularly important, by the party that lost an adjudication. There were several adjudication decisions on several different contracts, but this point related to one of them, then is the Westfield contract. And the first point was that the party that was on the paying end stated that there wasn't a crystallized dispute because it was asking questions so as to find out whether there was a dispute or not. The second point was a jurisdictional one. I will deal with crystallization first. It was a decision by Adam Constable QC, sitting as Deputy Judge of the High Court. And the first point he made was that requests for information first showed that the claim was not so ill-defined that one couldn't even know there was a claim, because the defendant was able, the responding party was able to ask questions about it. And second, that the very exchanges gave rise to a dispute as to whether there was a claim with sufficient evidence to justify it at all. And so Adam Constable went on to say it would be rarely relevant or appropriate in seeking to demonstrate that a dispute had not crystallized to look at the requests for information which have followed the presentation of a claim. That's quite important, because very often the party in the receiving end, particularly if it's a claim up the contractual chain, will be saying, to understand what you're saying, I have to get some answers to some questions. And yet you have there quite a strong statement that that isn't even relevant to deciding whether there's a dispute that hasn't or has crystallized. The other point that was made was that the defending party, we'll keep that up on the screen, but the other point in relation to crystallization was that the first response that me as the defending party made was, we say to you that your final payment claim isn't yet a valid claim under the terms of the contract. They didn't initially say your figures as figures are wrong. And so the second point they tried to make about crystallization was there might have been a crystallized dispute on the first point, but not the second. And it was held that that was artificial. Once one was saying that one was rejecting the final payment claim, as it was called, or a final account claim, as we'd normally call it, that was a dispute about whether there was a final account claim that was due. And therefore, it didn't matter that the second point, as to figures as figures, hadn't yet been specifically taken. And that's another reason that's important for COVID purposes, because one can't have the salami slicing tactic of taking all the points that one wants to take in relation to a dispute consecutively so as to slow crystallization down. Let's go over to the next slide, which is about multiple contracts. The point here was simply that some of the money, it was £2,400, that was being claimed related to work done on a separate site, not the Westfield contract site itself. And so the jurisdictional point was taken, this is money due under another contract, so we, the responding party, say we have an arguable case on that, therefore summary judgment should not be given. And the way that was dealt with was very succinct. There was a notice of adjudication under the Westfield contract. It asked the question, is the sum due? Therefore, as a matter of jurisdiction, the adjudicator had jurisdiction to decide whether or not that sum was or not due. There was another jurisdictional point, which I haven't put up on the screen because it's not a new point for adjudication purposes, but it's a further case under the Bresco and Lonsdale case, which David's going to talk about, although not in connection with jurisdiction. If you go to paragraphs 92 to 94 of Bresco, you'll see the test by Lord Justice Coulson about general reservations of jurisdiction. And the basic point that Lord Justice Coulson made there was that general reservations of jurisdiction are going to be treated differently in connection with adjudication and arbitration. In arbitration, that might work. In adjudication, the courts really don't want them to work. They take the view that if you knew or you should have known that you had a jurisdictional objection, you should take it. You can't rely on a general reservation. And if the court takes the view that you're simply trying to keep your options open, then you can't rely on it either. Of course, parties do take these general points specifically for that reason. There is wording which you'll have to find in the judgment itself in LJH paving, where there was a general reservation, and that was seen as too vague to be sufficient. And therefore, the lesson from that is if you have objections, try to work out all your objections and take them all at the start. Don't try to hold objections up your sleeve. Okay.
Let's go and look at Dickey and Moore again. This is Dickey and Moore against McLeish and number 2. Because the first part of that case had actually decided that the dispute had not crystallized, and the issue then was anything left over from that decision that could be enforced. So we go on to this point, which emerges in a number of cases. Can you sever an adjudicator's decision? Contractual argued that the adjudicator did have jurisdiction to decide the remainder of the dispute, so the decision could be enforced. The employer, on the other hand, argued that the decision was a unity, so none of it could be enforced. So this is an interesting case because it's a single dispute, accepted as a single dispute, and it's a question of severance within that single dispute. Lord Doherty comprehensively reviewed the decisions both in England and Scotland on the issue of severance. So if you have a severance case, this will be a good repository of jurisprudence to review your case. But one paragraph that does emerge, which has been quite persuasive, is on Lord Justice Coulson's writing extrajudicially his book on construction adjudication, where he notes that accordingly, even where there is a single dispute, it appears the court may, in the right circumstances, be prepared to enforce a part of the decision if the adjudicator, if that part is clearly and obviously untainted by a jurisdictional or natural justice problem and can be readily identifiable. The problem is, of course, if you have a single dispute, it's going to be harder to establish that part of it is still untainted by the part which has been excised off. Lord Doherty in particular considered the more recent case of Willow against MTD contractors and echoed the test used by Mr. Justice Pepperell in that case, when considering if anything is left that can be safely enforced once one disregards what is obviously flawed reasoning. And the critical test is whether it is clear that there is a core nucleus of a decision that can safely be enforced. And in the case of Dickey, it was held that severance was available, even where there was a single dispute. And the judge didn't go through this in detail, and he said he wasn't going to go through this in detail. It's a relatively broad brush approach. And he did note that it might be more difficult to show it has no impact in a single dispute case, as opposed to a case where more than one dispute has been referred to an adjudicator and the other disputes can be parked and left unenforced. Agreed with Justice Pepperell's observations in Willow, they need to identify a core nucleus of a decision unaffected by the complaint. So one point that does emerge from the case was the adjudicator's decision on apportionment of his fee. Of course, we've seen, and you've heard from John and myself, that there had been a lot of argument about different aspects of the decision, and parts had been severed. Of course, the issue as to the fee, the judge said, yes, the adjudicator might well have got that right, but it wasn't going to retro-engineer that part of the decision. And so that part of the decision wasn't enforced. So some aspects of a decision were safely enforced, but not the question as to the adjudicator's fee. And that's something that has emerged in earlier cases as well. So be aware of that. As John foreshadowed, we might well be revisiting the Bresco and Lonsdale case when it comes to adjudication post COVID-19, not least because of the issue of cash flow in the construction industry and the problem and the risk of insolvency of parties, contracting parties going into insolvency and then subsequently seeking to adjudicate their rights, potentially under the guidance or guise of an insolvency practitioner. And at first instance, of course, in Bresco against Lonsdale, Mr. Justice Fraser held that there was simply no jurisdiction, and that part of the decision was overturned on appeal to the Court of Appeal. It was held the adjudicator did have threshold jurisdiction to determine a claim where the referring party was insolvent. However, what the Court of Appeal didn't interfere with was the resulting order for an injunction prohibiting the continuance of the adjudication, simply because in most circumstances the exercise would be futile. And when we look at the analysis of Lord Justice Goldston, we can see why. He said it would only be in exceptional circumstances that a company in insolvent liquidation and facing a cross-claim could refer a claim to adjudication, succeed in that adjudication, obtain summary judgment, and avoid a stay of execution. And so the injunction was continued on grounds of practical utility. The question, however, is what are those exceptional circumstances that would allow a company in insolvent liquidation to successfully prosecute a claim to adjudication and then to enforce and to avoid a stay on the Wimbledon and Vago principles. And that was what was explored in Meadowside against Hill Street Management Co. Ltd. Here the claimant was, Meadowside was in insolvent liquidation. The other side asked the adjudicator to resign. He stayed on, and the adjudicator decided a net balance in favour of Meadowside. And the point that emerges, however, from this is this wasn't a payment notice dispute. This wasn't a smash and grab. This was a final account valuation. Also, it was after the defect rectification period, so any questions as to defects had to a large extent been put to one side. And also, this was the only contract between the parties. As you remember from Bresco and Lonsdale, both in first instance and in the Court of Appeal, part of the issue was mutual dealings and insolvency set-off, where you could bring in one contract against another when it came to the insolvency process. So this wasn't going to be an issue in the Meadowside case. But if we turn back to Meadowside, the adjudication proceedings have been brought by a company, Pythagoras Capital Limited, which acts for insolvency practitioners. It itself had given an undertaking to discharge any liability on behalf of Meadowside and has offered guarantees in respect of enforcement, and the understanding being that if any sum was successfully enforced, received and then defended in litigation thereafter, then Pythagoras was going to receive a healthy slice of the resulting damages. Now, HMC's argument was that this was champetous, and effectively this was a maintenance and champety. And the TCC judge did agree that it was arguable that this was a champetous arrangement. Just to pause there, champety is where a person with no previous interest in a lawsuit finances it with a view to sharing the proceeds if they win. In common law, such agreements are unenforceable, but there are some exceptions, the main one being conditional fee agreements, but also damages-based agreements under the 2013 regulations. It's not necessarily the case that something that is champetous is an abusive process, but it can be. And in this case, it was indeed held the proceedings were an abusive process. But what the case does consider, and why it's useful to note, it did consider the circumstances where the balance between the insolvency rules and insolvency set-off and the 1996 Act right to adjudication would be in favour of enforcement. First of all, there has to be no cross-claim, or where the adjudication determines the final net position between the parties. So this is not a case where the possibility of there being insolvency set-off will arise. For example, no separate or further contracts between the parties. Also, payment notice disputes are not suitable because they're not final, whereas in the Meadowside case, this was indeed a final account dispute. There needs to be a satisfactory guarantee or security in relation to a sum that's been awarded in the adjudication, or where the sum is temporarily ring-fenced pending it becoming finally due. And that is to sidestep the Wimbledon and Vago, no N on Vago principles, otherwise they would be engaged. I've got a question up on the screen. I've been asked, if there's a no set-off clause in the contract, will the courts uphold this clause and uphold the intended agreed contract terms? It's difficult to see how a no set-off clause would operate in respect of a contract. And the problem with the insolvency rules is once a party does go into insolvent liquidation, then a party is entitled to bring anything, any other contracts, any other sums due into the effectively into the whole pot, because set-off is a perfectly valid way to bring a defence in insolvency proceedings. So in my opinion, it would be very difficult to use a no set-off clause in the contract because of the rules as to dealings and insolvency set-off under the Insolvency Rules 2016. So I think it does go past that, and indeed on a summary judgment application for enforcement, I think, although it hasn't been tested given the age of Bresco and Lonsdale, I think it might be difficult to argue such a clause given the rules as to insolvency dealings. A third factor that the court considered is a question of satisfactory security made in respect to an adverse costs order in the ensuing litigation, or of course arbitration, such as an enforcement or litigation. And the fourth point then emerges that an agreement as to funding security must not be an abusive process. And in this case, it was arguable that the Meadowside Pythagoras agreement was champitous and was an abusive process. And to adopt those delightfully sounding medieval terms, it was maintenance and champity. I think the key takeaway point is the vast majority of adjudications that we see brought by company liquidation are not going to be suitable, irrespective of the question of security, and that a court is going to injunct a party seeking to try to sidestep the Bresco and Lonsdale case, or simply refuse to enforce a decision, or to grant a stay of execution on the Wimbledon and Vago principles. I'd like to thank everyone for listening. First of all, I'd like to note that John has written a series of 3 excellent articles about how different forms of construction contracts deal with issues such as force majeure, and they're very well worth a read, and they're extremely useful when advising on that. The slides are going to be available after a few hours after this presentation has been given, both the slides themselves and the recording. And so you can access John's articles on the first link. Also, this is part of a series of webinars about construction, development, and related areas. There's further details about that on the Chambers website. Also, more COVID-19 related material is on the website. It's in its own special category, and you can find that again on the third link. I've been asked a question arising about a Meadowside case again. Would assignment of a debt avoid Bresco if it was a final account dispute? This would ignore the standard JCT prohibition on assignment. I would I think at that point, it's going to depend from case to case, particularly with when you have companies, for example, going into administration as well as liquidation. I think it's going to be, you have to be quite careful about bringing any claim through adjudication, given the inherent incompatibility of the adjudication process as a binding but interim form of dispute resolution and the nature of insolvency, which of course is a public remedy designed for the benefit of a company's creditors, rules as to insolvency set off. So I think it's going to be difficult, and I think it's one of those ones you have to advise on from case to case, given the state of the company and the state of the contract and any dealings between the companies, and indeed who is bringing the claim itself. So quite a multifactorial, almost a protean series of considerations there in answer to that question. And I therefore would like to thank you all for attending. If you have any further questions, our contact details and our links to our Chambers profile are up on the screen. Please don't hesitate to get in contact, and I wish you all best of luck in your forthcoming adjudications as we move forward. And from behalf of John and myself, we'd like to say thank you and goodbye.